In this lecture, we will discuss the same debate that was continuing since 1986 after the landmark decision delivered by the Bombay High Court in regards to right to die as whether it is falling under Article 21 of the Constitution of India and in particularly also the decision and judgment delivered by the Delhi High Court in the case of State versus Sanjay Kumar Bhatia in 1994. So the very debate continued regarding the section 309 of Indian Penal Code which criminalizes attempt to commit suicide. So the very debate and the controversy even after the landmark decisions of the Bombay High Court in 1986 relating to Maruti Sripati Dubal and the decision of 1994 by the Delhi High Court relating to State versus Sanjay Kumar Bhatia. The same subject is continuing as a debate in legal and constitutional circle whether Section 309 of Indian Penal Code is constitutionally valid or it is unconstitutional and whether right to die is falling under Article 21 of the Constitution of India. So, the very controversy is around attempted to suicide. So, in this particular leading case in 1994, the petitioners P.Rathinam and Nagbhushan Patnaik versus Union of India, they made the very argument that Section 309 of the Indian Penal Code, which criminalizes attempted suicide or attempt to commit suicide, is unconstitutional and it is a violation of the fundamental rights guaranteed under Article 21 of the Constitution. So, the very ruling and judgment of this in where Supreme Court expresses that the right to life under Article 21 of the Indian Constitution also includes right to die, thereby striking down Section 309 of Indian Penal Code as unconstitutional. So this judgment was significant as it recognized an individual's autonomy over their own life choices. And it also provided a humanitarian perspective on the issue of mental distress, mental illness, and the various causes of suicide. So now we'll examine the very facts whether it is constitutionally valid or the constitutionality of Section 309 of the Indian Penal Code which relates to attempt to commit suicide by the petitioners and they were under criminal prosecution. So, the very facts of this case as relating to the very case of P.Rathinam and Nagbhushan Patnaik and in the joint petition as filed by the petitioners against the state that is vs. Union of India. Even though they filed separate petitions challenging the constitutionality of Section 309 of Indian Penal Code. Section 309 of the Indian Penal Code provides that anyone who attempts suicide shall be punished with simple imprisonment of up to 1 year or a fine or with both. And the very petitioners in this important landmark case argued that this very provision of the Indian Penal Code violates the fundamental rights and was contrary to dignity of life as it includes right to die with dignity. So, one of the petitioners, that is P.Rathinam, attempted suicide due to extreme distress. However, instead of receiving help, he was subjected to criminal prosecution. This led to the filing of a writ petition in the Supreme Court questioning whether a person attempting to take their own life should be punished rather than rehabilitated. The case was heard by a two-judge bench of the Supreme Court, which delivered the very judgment on 26th April 1994. So now we'll discuss those legal issues involved in this case. So in particularly the legal issues relating to that whether there is any violation of fundamental rights by doing prosecuting any such person attempting to commit suicide. And the second important issue relates to whether right to life and personal liberty. If it explains right to live with dignity, whether under it right to die with dignity falls or not, then very question raised regarding the unconstitutionality of Section 309 of the Indian Penal Code. So the very issues first of all raised that whether Section 309 of Indian Penal Code violates Article 14 and Article 21, while Article 14 of the Constitution deals with right to equality and equal protection of law, and Article 21 of the Constitution, which provides right to life and personal liberty. Besides that, another important legal issue that raised regarding Article 21, whether right to live with dignity, also include right to die with dignity. Then another legal issue and question that came over the Supreme Court whether Section 309 of Indian Penal Code be declared as unconstitutional as this violates the fundamental rights of a citizen. So, the arguments laid down by the petitioners, in particularly regarding the provisions of Section 309 as they are unreasonable and there is lack of compassion by prosecuting any person committing suicide or attempt to suicide for which it criminalizes the very section, that is Section 309 of Indian Penal Code. And besides that, the question raised regarding that it is argued by the petitioners on the ground of morality, public policy. Then we will discuss the arguments laid down by the petitioner by making reference to UK, United Kingdom Suicide Act 1961 and the 1971 report of the 42nd Law Commission of India. So, the petitioners' first argument that Section 309 of Indian Penal Code is harsh and inhuman as it punishes a person who is already in mental distress and in need of support and counseling. And the second argument laid down by the petitioner, a person who attempts suicide is not harming anyone else and is criminalizing such an act is unreasonable and lacks compassion towards the person who is attempting to commit suicide. Further, the arguments laid down by the petitioner is that suicide is not immoral or against public policy. Different cultures and religions have different views on life and death, and it is unfair to impose a single standard of prosecution without ascertaining the various causes and grounds of committing suicide. Further, the petitioner raised the issues relating to other countries, in particularly United Kingdom, which had repealed laws criminalizing suicide by the Suicide Act 1961. The United Kingdom decriminalized suicide, recognizing the very need for a human and compassionate approach to such persons who commits or attempt to commit suicide. The further arguments made by the petitioners relating to the report submitted by the 42nd Law Commission, which in 1971, which has already suggested in their report removing Section 309 of Indian Penal Code as it serves no real purpose, as it is inhuman and lack compassion. Now we'll discuss about those arguments tendered by the respondent, and that is the Union of India, in particularly that it leads to euthanasia, then law and other problem, then against public policy, and there would be misuse of criminal law by the citizens and persons. So the respondent Union of India through its councils expressed that suicide is against public policy as it weakens society by allowing individuals to take their own lives at their own will. Further, the state argued that an interest in preserving life is the primary goal of the state, and allowing the right to die would weaken the very fabric of law and order. Further, the respondent led the argument that the state punishes individuals, including criminals on death row, to maintain law and order. If the right to die is granted, it could be misused by those criminals who are convicted and imprisoned for a long period in different prisons. So this would be misused by them by allowing any person the right to die. Further, the respondent argued that allowing the right to die could encourage euthanasia and also passive euthanasia, that is assisted suicide, that already we have discussed in our previous lecture, which may lead to misuse and forced deaths. So now we'll go to the aspects of the judgment. And in this particular landmark judgment, where Supreme Court struck down at Section 309 of the Indian Penal Code and also held Section 306 as valid, and further the judgment held that Section 309 of Indian Penal Code violates the fundamental rights as it is unreasonable, outdated, and cruel. So, after hearing both sides, the judgment led to the following criteria: that Article 21 guarantees the right to life, and just as freedom of speech under Article 19 includes the right to remain silent, The right to life includes the right to die. Further, the judgment also cited criminalizing suicide attempts violates human dignity, as it punishes individuals who are already suffering from mental illness, mental agony, mental health, and mental distress. Further, the judgment cited that suicide is not always an act of immorality, or it may be a person's last resort to escape humiliation, torture, and unbearable suffering. Further, this judgment led to express that Section 309 of Indian Penal Code is cruel, unreasonable, and outdated, and repealing it would bring Indian law in line with progressive legal systems of other countries. Finally, the Supreme Court bench held that Section 306 of Indian Penal Code, which punishes for abatement of suicide, remains valid, as it involves helping another person to commit suicide, which is different from an individual's personal choice. So, the very judgment delivered by the apex court is overruled in 1996, and that was in the very judgment delivered by the apex court in Gan Kaur vs. State of Punjab in 1996. So, the judgment delivered in Gan Kaur vs. State of Punjab, it reinstated the very legal position of Section 309 of Indian Penal Code, and further it overruled that right to life does not include right to die, as provided under Article 21 of the Constitution of India. And it is not a fundamental right at all, and neither it is unconstitutional or against the provisions of Article 19 and Article 21 of the Constitution, which provides fundamental freedoms and right to life and personal liberty. So finally, the apex court or the Supreme Court in this landmark judgment P.Rathinam and Nagushan Patnaik vs. Union of India in 1994, although held that Section 309 of Indian Penal Code is unconstitutional and it violates the fundamental rights as inherent under Article 21 of the Constitution of India. But as it was overruled after 2 years in the landmark judgment Gan Kaur vs. State of Punjab, where the apex court declared that Section 309 of Indian Penal Code is not unconstitutional. Neither right to life includes right to die. And also it is not a fundamental right as provided under Article 19 and 21 of the Constitution of India. And in consequence to these decisions, the Parliament of India enacted the Mental Health Care Act of 2017, and in that particular act in 2017, mental illness and mental distress, and on the grounds of mental illness and mental distress, any person attempt to commit suicide is being decriminalized, and as provided under Section 115 of the Mental Health Care Act 2017 as it was decriminalized. Section 309 of the Indian Penal Code shows any person suffering in mental illness or in distress, then there would be no punishment to be awarded to such persons as provided under Section 115 of the Mental Health Care Act of 2017.